Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3018, United States of America versus James Little, appellant. Mr. Carpenter for the appellant, Mr. Pierce for the appellant.
Good morning, Mr. Carpenter.
Good morning. May it please the court. Josh Carpenter on behalf of James Little. Your Honor, we've reserved 3 minutes for rebuttal. Your Honor, the sentence imposed in this case for a petty offense consisting of a term of imprisonment followed by a separate term of probation is historically unprecedented. The government has not identified any court that has imposed such a sentence before the January 6th prosecutions. The district court opinions in this case and others that have justified this novel outcome are flawed for 3 primary reasons. The first is that they rely on a mistaken belief that the defendant's interpretation of the statute would create surpluses. The government has conceded on appeal that that rationale is mistaken. Second, the opinions below do not grapple with the contextual problems that the government's interpretation created, including the effective repeal of the 1987 amendment that prohibits supervised release for petty offenders. And third, these opinions step into a policy or legislative role by purporting to fill what they perceive as a gap in the statutory scheme. But to the extent that such a gap exists, it is Congress's role and not the court to fill that gap. And I'll start with the surplusage point. Judge Lambert, in the opinion below, recognized that there were 2 ways to read the text of this provision, one corresponding to a last antecedent interpretation and the other to a series qualified. In choosing between those 2 interpretations, Judge Lambert relied heavily on the idea that the last antecedent interpretation would create surpluses by rendering the phrase, "that is not a petty offense," meaningless and inoperative. That was an argument that the government made below. Judge Lambert adopted it, but now on appeal, the government recognizes that that was an error. Under either of these interpretations, the phrase, "that is not a petty offense," does play a role. It changes the possible sentencing outcomes in cases that involve multiple petty offenses.
So you concede that under your reading of the statute, a judge could impose a split sentence for conviction of multiple petty offenses?
Yes, with one clarification to that. What can happen in a case that has, say, 2 petty offenses, for example? On one of the petty offenses, the court can impose imprisonment. On the other offense, the court can impose probation. So it is not a split sentence in the sense that one of those counts in a multiple offense case can receive both imprisonment and probation. The split sentence or dual sentence or whatever you want to call it comes about because there are 2 offenses of conviction. And under A3, under either interpretation, it is permissible to impose imprisonment on one and probation on the other.
You don't have anything in the legislative history that supports that reading of the statute, do you?
Yes, Your Honor. So when the 1994 amendment was passed, there is nothing, as far as I know, either way in legislative history that tells us what Congress is doing other than the words that it used. However, you do have the 1991 proposed legislation, which purported to do exactly this, to allow imprisonment on one and probation on the other. Now, the government sort of makes a big deal of this idea that, well, that can't be the interpretation because it would make no sense for Congress to want to treat multiple petty offenses differently than a single petty offense. I would say, as an initial matter, I think there's all kinds of reasons Congress might want to do that. But more on point, the 1991 legislation shows us that at least the sponsors of that legislation thought it was a good idea as a matter of policy to treat single and multiple petty offenders differently. So I think that does support the idea that this language that was added a few years later in 1994 does support our reading.
But nothing in the legislative history from 94 harkened back to 91, right?
Correct. To my knowledge, the legislative history in 1994 is silent both ways. There's simply nothing other than the text that Congress passed to tell us. So we do not know if the change that happened from 1991, the proposed legislation, to the 1994 enacted legislation was intended to be a substantive change, or whether it was simply somebody in the committee drafting process saying, look, this is a 30-word sentence, 39-word sentence. I think we can accomplish the same thing by tacking on this 6-word modifier at the end of A3. And look, I've saved 30 words. You know, my law professor is going to be very happy that I've cut out all of these words, not realizing that cutting it from 39 words down to 6 words created ambiguity about the meaning.
Mr. Carpenter, one of the first things that you said is that this type of sentence is unprecedented and that it has not been imposed before January 6th, but the events of January 6th were themselves unprecedented, right?
Sorry, I couldn't quite hear that last part.
The events of January 6th were themselves unprecedented, right?
Well, that is certainly true, Your Honor. But I think that does not justify the courts in bending the rule of law. I think the rule of law, the statutes that are on the books exist and are to be followed. And if Congress determines, in light of this unprecedented event, that the sentences provided for in the current statutory scheme are inadequate, it is incumbent upon Congress to make that move.
I understand. The district court opinion, if I'm remembering it right, there read several, but I think it focused quite a bit on whether same is an adjective or a noun. And your brief focuses on the dueling canons question much more than it does on trying to argue that the same is a noun. Same is a noun. I guess I'm wondering kind of what your thinking was in emphasizing canons over emphasizing same is arguably a noun.
Sure. So I think there are two things I would say there. The first is sort of the overarching point that I do not think the choice between the two interpretations here can be determined by looking at the text alone. And I point to the Confederated Tribes case from the Supreme Court recently, which said the most grammatical reading of a statute in isolation is not necessarily the correct reading in the broader context. That's why, in our view, the choice between these two interpretations ultimately comes down not to canons or to grammar, but to the broader statutory.
Let me be a little more precise. Do you think same is an adjective or do you think it's a noun?
No, thank you. And that was the second point that I was to make was I think that it is an adjective. And I disagree. The whole parts of speech analysis in Judge Lambert's opinion, I think, is beside the point. I think it's a red herring. I think what it overlooks is the same thing that the government's integrated phrase argument in its briefing on appeal overlooks, which is that what we have here is an elliptical construction where everyone who reads this, I think most reasonable readers who look at this, understand saying the word offense is modifying, or is present is just omitted. It's present as a matter of grammar.
So let me then ask one kind of, I guess, I don't know, practical question. And I'm going to ask the government the same thing, but what's the difference between probation and supervised release, if any? There is any difference in a general sense.
For practically speaking, there's none. And the thing I would point to that I would highlight it because I don't think this passage was highlighted in the briefs. We both cited Senate Report 98-225 from on page 89, which has some similar language. But at page 125 of that same Senate report, the report says the term of supervised release, which was created by this legislation, it hadn't existed before, is very similar to a term of probation, except that it follows a term of imprisonment. That is the one and only difference between probation and supervised release. One is supposed to be, probation is supposed to be in lieu of, supervised release is supposed to be a supplement to, or in addition to, following. That is the only practical difference. You see that we cited in the reply brief some of the pieces of the statutory scheme that support that, where probation officers, for example, are given identical duties of oversight with respect to probationers and supervised releasees. So as a practical matter, they are identical. And that is why the government's interpretation of A3 effectively nullifies the 1987 amendment to 3583B3, which adds the prohibition on imprisonment plus supervised release for petty offenders. It would simply make no sense for Congress to have said in one provision, for a petty offender, you cannot give prison plus up to 1 year of community supervision, but to say in a different provision, but for a petty offender, you can give imprisonment plus up to 5 years of community supervision. The reading of those two separate statutory provisions simply does not mesh under the government's interpretation.
How would it work if your client were to violate the conditions of probation and the government were to propose that his probation be revoked? What if any additional imprisonment would he face?
Well, that depends upon whose interpretation of the statute controls. So on our view, we shouldn't have got probation first. But let's assume he was just sentenced to probation and then he violated. Our view is that upon revocation, a defendant in that circumstance could receive imprisonment full stop, not imprisonment plus additional probation. Under the government's interpretation, if you look at, I believe it's 3565A2, which is the revocation provision, it says that a defendant whose probation is revoked is resentenced under subchapter A. That means in our understanding of the statute that all of the penalties authorized by subchapter A are available anew. So in our view, under the government's reading, if we violate, he could get 2 more months of imprisonment plus 3 more months of probation, and that cycle will continue in perpetuity.
But that's not the way that it works even under supervised release, right? You can't serve a supervised release term beyond whatever the maximum is that is provided by statute, right?
That's absolutely right. And it's precisely because Congress addressed this scenario in the supervised release provision. If you look at 3583H, it contains a specific provision that says when there's a revocation, the amount of additional available supervision must be subtracted or must be reduced by the amount of time that the person has served in prison. In other words, Congress in the supervised release provision didn't rely on the general statutory maximum in 3583B, which says that for a Class A felony, it's a max of 5 years. That's the corresponding provision in the probation section. Each of them have that statutory max provision. In supervised release, Congress did not rely on that maximum. It included a specific provision, subsection H, that provides this limitation that prevents a never-ending cycle of re-imprisonment and revocation. The fact that Congress did not include a similar safeguard in the probation revocation provision, we think is strong evidence that Congress did not intend for probation to work the way that the government would have it work in this case.
I think Judge Rogers may have a question.
Okay, you've covered it.
Okay. When looking at the text, if your reading of the text is correct, then you still have all of these same problems that you identify for someone who is convicted of multiple petty offenses and who gets a sentence of imprisonment on one and a sentence of probation on the other, right?
You don't, and I'm so glad you asked that question because I don't think in rereading them that our briefs were clear on that point. So this never-ending cycle, under our interpretation, is not possible in a multiple offense case. Because if we go back to how that works, so let's assume 2 offenses. The court imposes imprisonment on the first, probation on the second. Well, the defendant serves the term of imprisonment, is released, and begins serving the sentence of probation. That defendant has completed the entirety of his sentence on count number 1. He can be revoked on count number 2. But at that point, the available sentences under our interpretation are either a continuation of probation under 3565A1 or revocation and imprisonment under A2. But under our interpretation, revocation the only thing available is imprisonment full stop, not imprisonment plus yet another term of probation. Because again, in a multiple offense case, the split sentence arises not because any one of those counts can receive both forms of punishment. It is because you have two separate offenses, and each one of them can have a different type of punishment. So imprisonment on one, probation on the other. But the cycle ends after one revocation in a two offense case. And if there are other questions at the moment, I'm happy to answer them. Otherwise, I'll yield until rebuttal.
Any other questions, Judge Rogers?
No, thank you.
All right, we'll give you some time on rebuttal. We'll hear from the government. Mr. Pierce.
May it please the court, James Pierce for the United States. The district court lawfully imposed a sentence that included a term of imprisonment followed by a term of probation. When Congress appended the words, quote, "that is not a petty offense," unquote, we call the petty offense clause, to the end of section 3561A3, it empowered sentencing courts to impose the type of sentence that the district court imposed here. Even if that sentence were erroneous, however, any error would be harmless because the district court could have imposed essentially the same sentence under section 3563.
How would it be essentially the same sentence if you say that it would be maybe weekends in jail up to, I guess, whatever it's 60 days? Some sort of intermittent confinement?
It would be intermittent confinement, I think, refers to the weekends and nights. What 3563 says is weekends, nights, or other intervals of time. Other intervals of time is not defined in the statute. We think that the best reading of that is probably up to about 14 days. So it is true that it would not be the 60 days continuously that the district court here imposed, but certainly that would readily encompass the 60 days. 3563 allows for actually all the way up to a year's worth of imprisonment during the first year of probation, which, if you do the math, would actually suggest that an interval of time theoretically certainly at some tension with the legislative history. But the point for this case is that certainly that would encompass the 60 days that district court here imposed. Now, I'd like to go back to
But what do you do with the fact that if under that construction, the sentence still would have been illegal in the sense that you're not contending that 60 days constitutes an interval of time within the meaning of that provision, right?
So, candidly, I think that's a tougher position. Obviously, we want to prevail on our top line position that, of course, this was fully statutorily permitted under 3561A3. I'm not going to fight too hard if the court concludes that was an illegal sentence.
Well, I mean, I'm trying to understand because ordinarily then we don't reach, the merits of an argument if there's a meritorious harmless error argument. So that's why I'm starting there to see, is this a meritorious harmless error argument or not?
I think it would depend on interpreting intervals of time. And as I said, though there is no governing interpretation either statutorily or under the case law, the court would have to read that would permit a sentence up to 60 days. There is language in 3563 itself that would seem to suggest that. As I said, the fact that a full year's worth of probation could be imposed, not here, of course, of imprisonment, rather, not here because there's a statutory maximum in the petty offense of 6 months. So it is not obviously incorrect, though I do think there is some countervailing position in the legislative history. If this court were to disagree with our top line position and to disagree that it was harmless, we would nonetheless ask for a remand where Judge Lamberth could then evaluate whether to either impose some sort of sentence under 3563 or impose a longer term of justice. With that, I'd like to return to the textual argument. I'm sorry, yes.
Well, let me ask you the question that I asked opposing counsel. He said there's basically no difference between probation and supervised release. Is that right?
I think that's basically right. The probation
costs about the same amount. They both allow for basically the same restrictions.
Yes, I mean, of course, in any individual case, there'll be different conditions, but, and I think there are some that conditions that may not apply to one or to the other, but I think functionally that's an area of common ground.
Let me ask one other kind of actual background type question. The maximum amount of imprisonment for Class A misdemeanor, Class B, and Class C, as I read 3559, Class A up to a year, Class B up to 6 months, Class C up to 30 days. Maybe you don't have it memorized off the top of your head. Does that sound right?
I believe that's right. And then there's an infraction that's up to 5 days that sits even underneath the Class C. But that's, I think that's correct.
Thanks.
So turning to the textual argument here, the district court correctly concluded that the petty offense clause governs the whole phrase, the same or a different offense. In so doing, the court concluded that the same was an adjective. I think I heard my friend on the other side agree with that determination here today. And that's a matter, I think, of just common sense. The same or a different offense was legislated initially when Congress passed the Sentencing Reform Act in 1984. It didn't change it in 1991 when they considered but ultimately declined to adopt a reading that I think the parties agree would unequivocally have supported the defendant's reading here, but instead added that is not a petty offense to the very end of 3561A3, didn't set it off with a comma, didn't use the word offense after the same. And even applying the last antecedent canon, if one gets beyond grammar and wants to get into a question of canons, it's not clear that that actually accomplishes what the defendant is hoping that it does. Still, sorry, was there, the canon would reach certainly offense, but that still leaves the broader question, well, what offense are we talking about? And the offense is the same or a different offense. It encompasses the entire phrase there. To read it the way the defendant would have the court read it, you have a different offense that is not a petty offense, and then you just have the word the same sitting out there. And yes, I suppose one could just write the word the same in, but another area of common ground, and I think this was the third point that my friend on the other side made in sort of standing up, is it's not the bench's role, of course, to write in words that Congress has opted not to include. Congress could well have written the offense right after same. I think that would have made it a much closer argument and potentially one that we would lose. But this court is interpreting the text that we actually have, and that is, in fact, one that would have the petty offense clause cover the full phrase, the full interpretation. I'd like to address the surplusage question. I know there weren't any questions or surplusage issue, but that was also one that my friend on the other side raised. That's a bit of a straw man here. Below what the defendant argued was asking Judge Lamberth to adopt the reading, the then reasoning of Judge Collar-Catelli in a case called Spencer. And in Spencer, the court had said, under no circumstances could a sentencing court impose a sentence that included both imprisonment and probation. And Judge Lamberth below, in dealing with that question, said, well, that would render the phrase, that is not a petty offense, meaningless. And clearly it had some meaning when Congress specifically added it in 1994. It had to have some function. And so Judge Lamberth said, at a minimum, it allows for the imposition of, or he doesn't say at a minimum, but that it allows for the imposition of both probation and imprisonment on a single petty offense.
Mr. Pierce, it's not our job to try to read the mind of Congress, of course, but it is our job to try to, look at the text in the broader context and see how different parts of a statutory scheme fit together. So I want you to have a chance to respond to what I think is one of the strongest contextual or structural arguments of Mr. Little, and that is, why would Congress have wanted a 1-year term supervised release for a Class A misdemeanor, but a 5-year term probation for a petty offense? And as part of your answer, I'd hope you would factor in your answer to my first question, which is there's basically no difference between probation and supervision.
So I agree it is somewhat a peculiar way to solve the question of post-imprisonment supervision for petty offense defendants. And again, I'm not walking back the answer. I don't think there's really a functional difference between between supervised release.
Well, but my question is not why would Congress have done probation for a petty offense and supervised release for a Class A misdemeanor? Fine. If they're about the same, it doesn't matter if one has one label. My question is why 1 year for Class A, 5 years for petty?
So there is nothing in the legislative history to help sort of answer that question one way or the other. I think the best answer or sort of a fair inference is that when Congress removed supervised release in 1987, it also made clear that the guidelines didn't cover petty offenses. This is in 3553B, and then the guidelines had a
Why is this a different scenario than, let's say, max penalty for first-degree murder, life? Sorry, I said it wrong. Max penalty for first-degree murder, 20 years. Max penalty for second-degree murder, life. That would be very odd to write a sentencing scheme that way. 20 years for first-degree murder, life for second-degree murder. Here, 1 year for Class A misdemeanor, 5 years for petty offense. Seems just as odd, right?
Well, to be clear, and this gets back to Your Honor's earlier sort of question or clarification, certainly this doesn't change the actual statutory term of imprisonment, which Congress and the courts in particular have said this is really what drives questions like eligibility for jury trial or something like that. Now, again, I don't actually have an answer. It is somewhat odd that Congress would do this, but Congress is fully empowered to do this, and for better or worse, it need not explain itself as to why it does that. But I think the other broader point here is one that Judge Wilkins' questions illustrate, which is that these same sorts of questions about the oddity or the anomaly of this arise just as readily in cases with more than one petty offense. And actually, I think that's a misreading. I think it could be a petty offense and any other offense, not even a petty offense, where you've got imprisonment on the petty offense and then probation on either the petty offense or potentially the non-petty offense.
I mean, maybe the answer to my question about the oddity, maybe not, is you think of the prison term plus, I'm just going to call it probation, but it could be supervised release. You think of that as like, okay, how severe is it in combination? And maybe, for every day in prison, it has a severity level of, let's say, 1. And for every day of probation, it has a severity level of, let's say, 1/1000th. And so if you combine prison plus the year probation, supervised release for Class A, it comes out to severity level of, I don't know what the math is, but let's say 400, 365 days plus. And if you do that for petty offense, it comes out to severity level of like 200, because the prison time is so much less that even 5 years of probation doesn't get you up to a severity level of 200. Is that plausible? What do you think?
I mean, that's plausible. Again, candidly, there isn't anything in the legislative history to kind of bear that out. I would add, though, that even with a Class A misdemeanor, for example, Congress could, in fact, impose a sentence that is similar to and certainly more severe as far as prison time is concerned. But and kind of back to the discussion of 3563, a court could impose a full probation of the same number of years and an amount in prison that potentially got up to a year. It's unclear, but certainly more than 60 days and more than 6 months, albeit likely in intervals kind of spaced out over the course of the year.
So before the 1994 amendment, the way that the statute read is that it ended with the word, after for the same or a different offense. And then there was a period, right?
Correct.
And so in your mind, then the interpretation of 3561A3 at that time was what? What work did that particular provision do?
That provision precluded any imposition of a term when someone is sentenced at the same time for one offense or multiple offenses, for a sentence that included both imprisonment and probation, with the caveat unless the imprisonment was a condition of probation under 3563. I think it was B11 at the time. Now it's B.
So just to clarify, you believe that prior to 1994, you could not impose a sentence of probation if there was also a sentence of imprisonment for any count that was being sentenced at that same time, except for the circumstance where imprisonment could be made a condition of probation. Is that what you're saying?
That's right. That's what I believe 3561A3 before 1994 did. After 1994, it certainly allowed for a split sentence. Of course, the dispute here, and this is an argument that the defendant raised for the first time on appeal, was, well, it's only available in multiple petty offense cases. We think that the district court read it correctly.
But you're not arguing forfeiture. You're not arguing that they forfeited that argument.
No, we haven't raised a forfeiture claim, a plain error claim.
So let me just drill down here. The way I read 3561A3 prior to 1994 was that if you sentence someone to a term of imprisonment, let's say there were 3 counts of any sort, they could be felonies, misdemeanors, petty offenses, didn't matter. If you sentenced someone to a term of, if you sentenced them to a term of imprisonment on any one of those counts, you could not sentence them to a term of probation on any of the other counts or do any sort of a split sentence, right?
That's right. Again, the caveat that you could make, you could start with probation and do imprisonment.
Yeah, but you could, if there's going to be a sentence of imprisonment, then probation is off the table for that count or any other count, right?
Correct. And supervised release would sort of play the role of post-imprisonment supervision. But
if you decided that you were going to sentence to probation on one or more of those counts, you couldn't do imprisonment unless it were a valid and legal condition of probation, right?
That's right, under 3563.
That's prior to 1994. So when Congress adds the phrase, that is not a petty offense at the end, that's the phrase that we want to see what work does it do, right? That's really the operative thing that we should be laser focused on, as opposed to necessarily fighting for the same or a different offense. And it makes sense to really look and see exactly what that is not a petty offense, what work that is doing first and foremost.
I think that's right. And I think there's agreement that carves out petty offense cases. The question is, what does a petty offense case mean? Is it a single one? Could it be a single one, or does it require it be one of multiple offenses?
So I guess what I'm saying is that why isn't the best interpretation of this is that Congress would want A3 to basically work the same way as it did before, but to the extent that one of the offenses is not a petty offense, then I guess I guess what I'm saying is, why isn't this intended to just exclude any petty offenses from the prior treatment?
We think that's exactly what it does.
That's your argument.
That is precisely our argument. And what I understand the defendants to say is, no, it has to be multiple petty offenses. No legislative history to back that up. I think no sound reason to understand why that would be the case. But it is our argument, and Judge Lambert below, this is sort of the surplusage point, made the same point. That is not a petty offense, has to do some work. And in our view, it carves out a petty offense conviction, both a single one or potentially an instance where it is one among a number of offenses.
What about this whole problem of the never-ending cycle of potentially of revocation and imprisonment, re-imprisonment, and reimposition of probation ad nauseum infinitum?
So a few comments about that, and certainly, as the briefs point out, this notion of a split sentence existed for some 25 years, from the late 60s until the Sentencing Reform Act, and that kind of never-ending revocation and re-imprisonment hypothetical was never borne out. Second, to the extent—
Never borne out because something in the statutory scheme precluded it? Or just as a practical matter, judges didn't do that?
So I think potentially both. It's hard to sort of answer a historical counterfactual. There was at the time something in the probation statute that did limit, in the way that a similar safeguard exists in the supervised release statute now. Admittedly, that doesn't still exist in the probation statute, but to the extent that's an issue, I mean, that's an independent concern, I think, with the probation statute. It's hard to see how that has relevance for interpreting the plain text of 3561A3. Again, the question there is, what does that is not a petty offense, what work does it do? Sort of drilling down into a potential flaw in the probation, in revocation of probation, is hardly something that moves the needle on the textual question that 3561A3.
So I guess your argument is that, perhaps Congress didn't realize that they were creating that issue when they added that it's not a petty offense, but that doesn't mean that, I guess we shouldn't enforce Congress's intent here with this statute.
That's right. It should have no bearing on the statutory interpretation question. I'm sure if one looks hard enough, one could find anomalies, and in various respects. And so we don't think that should have bearing on, as the district court concluded, a textual question that, in our view, is soundly decided by the text itself.
I think your friend on the other side admitted that they hadn't really spelled out in their briefing this argument about imprisonment on one count and probation on second count as being the way that the split sentence would be done. I guess I'm just trying to make sure I have your best response to that. Again, were you arguing? I haven't heard you argue any sort of forfeiture here at the podium. So what is your best response to that as the best reading of the statute?
So we don't disagree that a court could impose a sentence under the circumstance where a defendant is convicted of two petty offenses, or as I've said, I think in a colloquy with Judge Walker, a petty offense and even a non-petty offense. But there is nothing to suggest that Congress intended that to be the sole area in which that is not a petty offense. The petty offense clause does work. There is sort of no sensible reason why Congress would have done that. I think the best sort of understanding is, as Judge Friedman laid out in Kaplinger, Congress realized the gap created when supervised release was taken off the table and filled that gap by allowing for petty probation in a petty offense case. And so there's not dispute among the parties that it's available where there are multiple petty offenses. But nearly all of the problems and the sort of oddities that my friend on the other side flags, including the oddity of sort of the mismatch in a petty offense case having, a seemingly more draconian penalty, would exist just as readily in their interpretation as it would in ours. And it's hard to see why Congress in an instance would, in a two petty offense case, would somehow think, oh, a split sentence is fine there, but not in a single petty offense case. Now, if I can just make one final point.
Because it seems like before 1994, Congress was speaking to, we don't want split sentences where there is a single offense, imprisonment and conviction, and that's why they say for the same or different offense, right? Before 1994, they were saying we don't want probation and imprisonment for the same offense, which is kind of like a split sentence on one count case, as we have here. And we don't want probation and imprisonment if you got multiple counts.
Right.
We don't care what kind of offense it is. We just don't want probation and imprisonment. But then when they add that is not a petty offense, they're saying, okay, well, the exception is if one or more of the offenses is a petty offense. That's your interpretation.
Precisely. One or more. The same has to mean something. So either the same petty offense or a different offense, right? And so I think it's the same general rule remains in place. What the petty offense does is just carve out an exception for either a single petty offense, as we have here, or for petty offense and some other offense.
Judge Rogers, do you have any questions?
No, thank you so much, Judge Wilkins.
All right. Here, thank you,
Thank you,
Mr. Pierce. Mr. Carpenter, we'll give you 2 minutes.
Thank you, Your Honor. Judge Wilkins, I'll start with the question we just talked about, which I think is the core. What does this 1994 amendment, what work does it do? And I think to analyze that, it's helpful to step back and look at the progression of the statutory history with respect to petty offenses. So up until 1984, the statutory scheme says no split sentence for any petty offense. The split sentence provision that existed at the time carved out petty offenses. So up until 1984, no matter if it was one petty offense or multiple, you could not have both imprisonment and a period of probation or supervision after. 1984 amended that, allowed for 1 year of post-imprisonment supervision for petty offenses. That was on the books for 3 years, at which point Congress repealed it and went back for petty offenses to the rule that had been in place before 1984. So that beginning in 1987, as before 1984, no matter if it's one offense or multiple offenses, you cannot have imprisonment plus probation for a petty offense. The question then is, when they amended in 1994, how big, that we agree they're creating an exception, and now there is at least some circumstance where this is permissible. Our view is that it makes sense to interpret it narrowly, because if you interpret it broadly, you are effectively repealing the 1987 amendment, which puts in the other than a petty offense exclusion in B3. If Congress intended to do that, they would have done that. They didn't do that. So we have to give, in our view, that language a different meaning than it was given before.
I don't want to take your last 20 seconds of rebuttal, but then I have a question.
I'm sorry, say that again.
I don't want to take the last 20 seconds of your rebuttal, but then I have a question when you're done.
Oh, sure. So the other point I would make on rebuttal is with respect to the remedy in this case, we believe the correct remedy is a remand with instructions to strike the probationary term. The government now, for the first time in oral argument, has made a request to remand for resentencing. Our argument would be twofold in that. First, that they did not make that request for resentencing in their briefing as an appropriate alternative remedy. So we think that is waived or forfeited under this court's case law. And the reason that doesn't make any sense anyway is the double jeopardy principles prohibit it. I would point the court to the ex parte Lange decision from the Supreme Court in 1873, which if you interpret the statute like we do, it's on all fours. In that case, the sentence was the statute said a fine or imprisonment. The district court imposed a fine and imprisonment. After the defendant paid the fine, the district court realized its error and sought to resentence. And the Supreme Court said, because the defendant has already suffered one of the alternative punishments, it is beyond the power of the court to resentence. So we don't think, even if the government had made a timely request for resentencing as a remedy, that it would be appropriate under double jeopardy principles.
Judge Walker, do you have a question?
Well, you mentioned implied repeal a moment ago, and you also hit this point pretty hard in your brief as well. But I mean, it's not an implied repeal if it's an express repeal. And the government's point is that this is an express change to the pre-94 regime.
Sure. So I think the distinction, and maybe we're understanding express and implied differently. I think it's not an express repeal because the words other than a petty offense remain in 3583B3 to this day. Congress has never passed a piece of legislation striking those words. So maybe it's not an implied repeal, but what it certainly is it's a creation of surplusage. It's rendering those words inoperative. They have no practical effect. And
it's rendering words that were in a prior statute inoperative, not the words that are in the statute that was passed.
That's exactly right. And I would point the court to Justice Gorsuch's language in Epic Systems, which says that courts have a duty to interpret the law as a harmonious whole, rather than allowing different provisions to be at war with each other. Our view is if you give A3 the interpretation that the government wants, it puts that provision at war with 3583B.
At war and surplusage are not the same thing.
No, they're
war
not.
Means conflict, right?
Yes, and I agree with that. But whichever principle, I mean, I think that in our briefing we describe it as all three. I do think there are arguments that all three are the appropriate. It seems to me a lot like implied repeal because it is doing the exact same thing that repealing the language would have done. It seems to me a lot like surplusage because all of a sudden that language has no effect or meaning. And it also seems to me like it's creating a war between provisions because the two things just can't stand together. It does not make sense to say you can't do 1 year afterwards of supervision, but you can do 5 years afterwards of supervision. That is just a nonsensical scheme. And I credit my friend for admitting that this is peculiar, that this is odd. That
What do you think of my kind of 1 day of in prison is worth 1,000 days of supervised release in terms of severity?
So I think that's interesting, but I think there is one part of the statutory scheme that it conflicts with. And that is, if you look at the authorized terms of supervision, Congress isn't taking that view elsewhere, right? It is grading them in sort of a logical graduated structure. So Class A felonies authorize the most. Class C, it drops down. Class E, it drops down. Class A, it drops down. And then all of a sudden it jumps back up again under the government's interpretation. So it disrupts what is otherwise an orderly and logical statutory scheme. So our view is that rather than create these peculiarities, these oddities that my friend acknowledges exist under the government's reading of the statute, there is a perfectly sensible, perfectly textual reading of the statute available that avoids those problems. If that is a problem that Congress perceives going forward, it can fix it. And as the government acknowledges, there are other options available for district court judges going forward. There is intermittent confinement. It is qualitatively less severe than the punishment that Mr. Little suffered, which is why we do not think this is a harmless error. But that option is available going forward for district court judges who want to ensure that there is probation in the future, but also want to provide for some degree of imprisonment.
All right, thank you. We'll take the case under advisement.
Thank you.
Case number 21-1260, John M. Crim, appellant versus Commissioner of Internal Revenue. Mr. DeRusso for the appellant, Mr. John Schloy for the appellate.
Good morning, Mr. DeRusso.
Good morning, Your Honor. May it please the court, Joseph DeRusso on behalf of the appellant, John Michael Crim. I'd like to reserve 4 minutes for rebuttal. In this case, the tax court committed 2 errors of law, either of which entitles the appellant to relief. First is the tax court erred in concluding that after the amendments to 7441, that 7443 subsection F doesn't implicate separation of powers doctrine. And the second issue is that the 6,700 penalties that issue here are not subject to any statute of limitation, either under Code Section 6501A or the catch-all provision of 28 USC Section 2462. Turning to the first issue, in 2016, 7441 was statutorily amended to include the language that, quote, the tax court is not an agency of and shall be independent of the executive branch of government. This statutory language was added by Congress in direct response to this court's decision for Kurtetsky, and Congress clarified, as detailed in the Senate report, that, quote, the tax court is not part of the executive branch, close quote. Therefore, 7041 makes clear that the tax court is now an Article I court, and that through the Supreme Court's decision of Freitag, exercises judicial power and not executive, legislative, or administrative power. Consequently, because the tax court is an Article I court exercising judicial power, the president's removal power under subsection F violates the separation of powers doctrine. And the tax court's decision to the contrary was there. Wasn't
all of this ground covered in our prior opinion in Kurtetsky?
It was, and Congress read the decision, took issue with the decision, statutorily amended Section 7441, take that into consideration, and state in addition to the statutory language that to clarify that the tax court is not part of the executive branch.
It didn't say that. It says it's not an agency of the executive branch. That's the first part, right? What part of Kurtetsky was dependent upon the decision, our decision was dependent upon considering the tax court to be an agency of the executive branch?
I don't believe the decision hinged upon whether the tax court being an express agency of the executive branch, but I believe that the decision spoke in terms of tax court being under the executive branch. And I think we all can agree that the tax court is not a department. It's not the Treasury Department, the Department of Defense, the Department of Commerce. And it's also, but now the statutory language of 7441 holds it as not an agency, independent or dependent or otherwise. So
what part of our opinion in Kurtetsky changes, or should I say, what part of that prior opinion relied upon the fact that the tax court was not independent of the executive branch? Was there any part of that analysis that said, well, because the tax court isn't really independent of the executive branch, we find the scheme to be constitutional?
I don't believe that the opinion spoke in that manner. I believe the opinion spoke to that the tax court does not exercise legislative powers and is not an Article III court. Ergo, it's in the executive branch. Because the president is the head of the executive branch, there is no impermissible inter-branch separation of powers problem. But I don't think the decision that this court had spoke to or had an outcome determining principle that whether the tax court is an independent agency or dependent agency or an agency at all, had any bearing on this court's analysis in Kurtetsky.
We'll see that then how are we to, I guess what I'm saying is we're bound by a prior opinion of our court. You know, we can go on bonk and say that a prior opinion shouldn't be followed, but we're bound by it. We have this intervening statute, but if this statute doesn't change or impact the analysis of the prior opinion, then how is it that we should come out with a different conclusion today, or feel like we're not bound by that prior opinion today?
Well, and various circuits have different articulations of this principle of the prior panel precedent, but I'm pretty sure that this circuit abides with the general concept that if subsequent events take place that call into question the prior decision, then a subsequent panel is not bound.
Well, Congress can't overrule our interpretation of the Constitution, right?
That is true, but Congress can change the statutory scheme on which this court's statutory review was based. So
well, that's why I was asking the question. So the Congress, according to this language, change the scheme potentially two ways by saying, by clarifying, if it wasn't clear before, that the tax court isn't an agency of the executive branch, but you said that nothing in Koretsky turned on whether the tax court was an agency. And then the Congress made clear that the tax court shall be independent of the executive branch. And nothing in the prior opinion turned on whether it was not independent of the executive.
And I understand that, Your Honor, but I would submit that when Congress identifies a case that is problematic and subsequently amends the statutory language in response to a perceived problematic case, Congress is upsetting the status quo.
Well, what work is this language doing? Maybe that's a better question. What is the effect of that as far as the structure of the tax court?
I would submit, Your Honor, according to the Senate report, and I'm quoting here, the tax court would be enhanced by greater autonomy in its administration of fees it collects, as well as the clarification that is not part of the executive branch, close quote. So my view of the legislative history and combined with the statutory language in response to this court's decision is that the tax court is an Article I court. It's not a part of the executive branch. It exercises judicial power, albeit not Article III judicial power. And as a result, the fundamental statutory underpinning of Koretsky has been changed, and therefore this court is not bound on the prior panel rule to abide by Koretsky.
Didn't Koretsky acknowledge that the tax court exercises judicial power?
Yes, I do believe it did, and citing to the Supreme Court's Rytek decision, which makes clear that it operates and uses judicial power, just not in the Article III sense.
I have some statute limit. You have any more questions?
I don't want to dominate the questioning here, so I'll stop there.
Yeah. And on the statute, I want to ask statute limitations question.
Sure.
Number one is sort of a fact question. Do you know of any of Crim's clients, any clients of the tax shelter filed a tax return?
I don't know, and I was not trial counsel at the.
The Third Circuit said in the United States v. Crim, based on instructions provided by Crim's firm, many of its clients did not file federal tax return. Should I take that to mean that his clients did not file tax returns?
I'm not going to dispute that, and I was also counsel of record for the Third Circuit, so I don't have reason to believe that is a factually incorrect statement by the Third Circuit.
And then can you give me an example of a tax shelter promotion case, hypothetical case, in which statute of limitations would be triggered?
Sure. I'm promoting the shelter. You're the taxpayer. I claim, promote, interest income is not subject to taxation. Therefore, you don't have to report it. You file your 1040, you report your income, leave off the interest income. Service comes by, audits you, you have a 1099, interest from your bank or your brokerage house, and then, issues a stat notice based upon the deficiency, based upon the interest that is not reported. That would be a typical example of a portion of your tax return that it would be improper, that would be the shelter, but you still file a tax return. Another hypothetical, which is going on to this day, are the tax shelters regarding conservation easements. And those conservation easements, you have inflated valuations of the charitable contribution, the land that's being donated. Then you have an inflated charitable contribution and an inflated deduction. Again, those are tax returns that have been filed with the service that precipitate or demonstrate the promoter activity.
Okay, and I hope the IRS counsel was listening, because my question, if we adopt your interpretation of the statute, are those factual hypotheticals correct? Would they actually trigger a statute of limitations in terms of assessment?
And I would point, Your Honor, to 6700A2 Cap A, and it talks about, quote, a statement. A statement could be a tax return, statement made to the IRS, or a statement could be a non-tax return reporting. For example, quarterly statement, a 941 for FICA and FUTA. There could be numerous statements. A 1099 is not a tax return, but is an informational statement which then precipitates or allows taxpayers to compute a tax. There are a lot of tax returns or statements that I believe 6700A2 Cap A would include. Turning briefly, I've seen I'm over my time, but my textual argument for 6700 is simple. 6671A provides that the penalties shall be assessed in a manner the same as assessed and collected as the same as of taxes, except as otherwise provided by. 6700 itself does not have an express limitations provision, and 6703 Congress provided some additional exceptions or differences for, in particular, for example, the exception to the deficiency procedures. So as a result, we can take 6671, 6700, 6703, you get to the default 10-year statute of limitations on collection under 6502, and you get to the 3-year statute of limitations on assessment under 6501A. Now, again, 6501A, when there could be no return, there could be a fraudulent return, there could be a substantial omission of income. There are numerous clearly delineated exceptions to the statute of limitations. But when you read the statutory scheme in its whole, to my view, that those contemplated exceptions to 6501 are there. And as a result, this court should conclude that the decision below was erroneous. However, if 6700 isn't subject to any limitation provision in the code itself on assessment, then this court's decision in 3M regarding 2462 come to bear. And that court's, or that panel's decision, I believe, supports our reading that an assessment is the prerequisite, and the assessment is the beginning of the enforcement proceedings. And the 3M decision from this court cited favorably Judge Boggs' dissent in the Sixth Circuit opinion in Mulligan, which held to the contrary, at least as far as 6700 penalties in respect to the Title 20 statute of limitation catch-all provision. So with that being said,
I want to clarify something. You had in your brief the issues presented for review. The fourth issue, the last issue, was related to tax court failing to properly apply the summary judgment standard of review. Is that issue now basically of no moment? It seems like the government responded to that in their brief, and you didn't say anything about it in your reply brief. I don't think it's kind of neither here nor there now.
Correct, Your Honor. I believe the IRS and I will concede that starting on page 24 to 27 of its brief, they agreed that statute of limitations is a verification issue under 6330C1, or in the alternative, that my client was not given a prior opportunity under 6330C2 Cap E. And then as a result, the issue of the statute of limitations is appropriately teed up for this court's consideration. So that's my view of the government's concession.
Okay, so you were raising that kind of as a prophylactic measure to make sure that you would be able to present this issue, and since the government is agreeing that it's going to be properly before the court, we don't need to worry about that issue anymore.
Yes, because my take on the statute of limitations was Judge Labbers in his decision said that I couldn't raise the statute of limitations, and then proceeded to address it arguendo as an alternative. So I obviously had to address that first proposition that it was properly before the tax court and that there was a material issue of fact, even assuming that it was not a verification under C1 as to the prior opportunity, which I made much ado about whether there is this registered number or what have you, what was available in the administrative record. So.
Thank you. Judge Rogers, any questions?
No, thank you, Judge.
All right, thank you. We'll give you a couple minutes on rebuttal. And now we'll hear from Mr. John Choi.
May it please the court. My name is Matthew John Choi. I represent the appellee, the Commissioner of Internal Revenue. Crim must pay. He owes tax penalties as a result of his tax shelter promotion activities. There is no dispute as to those liabilities or as to the amounts of the penalty. Because he has not voluntarily paid those penalties, the Commissioner now seeks to collect involuntarily through an administrative. Crim has raised multiple arguments as to why the Commissioner's levy should be, in effect, fully stopped or further delayed, but those arguments lack merit. This court should affirm the tax court and find there's no reason to stop collection because there is no statute of limitations violation. And this court should find there's no reason to further delay collection because there's no constitutional problem.
I agree with Crim on 6501 and 6670. In other words, if I think, okay, 6671 says the word tax includes tax penalty, and 6501 refers to a statute of limitations for tax. I know you disagree with all that. Let's assume that I'm with Crim that there's a possibility that that leads to a result where the statute of limitations will still never run in a tax shelter case because statute of limitations doesn't apply when a return is fraudulently filed. That's going to be a large category of these tax shelter cases, I think. And then it also doesn't run until a return is filed. So my question to opposing counsel was, well, when would a return trigger this statute of limitations if his interpretation of the statute is correct? I think maybe the answer is never, but maybe it's possible that a return, if he's right about the statute, could in some hypothetical trigger statute of limitations in a tax shelter case. So my first question to you is, if he's right about how to read 6501A, will the statute of limitations for a tax shelter case ever be triggered in the real world?
I think that's, I apologize, that's a difficult question to answer because you also have to then, I think, add one more piece. And Crim argues that the promoter penalty would then relate to the tax return of the taxpayer, but we disagree with that. When you look at the Ninth Circuit's case in Estate Preservation Services, the Ninth Circuit held that the penalty is all about the misrepresentation made by the promoter, right? Once they've made that misrepresentation, the offense is over. Taxpayer reliance isn't an element of the offense. But if it did relate to the tax return of the taxpayer, then under your hypothetical, Your Honor, then yes, the time limit would start. But we, of course, argue that 6501's limitation is for the filing of a return, which there is no return that relates to the promoter penalty. No return will ever be for the promoter.
What about 6501A apply? Does it ever apply to a tax penalty?
Yes, Your Honor. There are other penalties that do relate to returns.
So how do we tell which tax penalties are covered by 6501 and which are not?
Well, one way, Your Honor, some of the other penalties that would be covered, have special rules that show that they relate to the returns. For instance, the return penalty for preparing returns, false returns specifically relates. But for other penalties, because they don't relate to any particular period of time, or there simply would never be a return filed. It's just for making or furnishing a false statement while marketing a tax shelter.
Do you think that the possibility that even if Crim's interpretation of 6501A is correct, do you think the possibility that it will not lead to the statute of limitations ever being triggered? This would have to bake in your theory that a filer's return or the client of a tax shelter's return does not trigger the statute of limitations. Do you think that possibility should inform our interpretation of 6501A, or do you think, well, we should just figure out what 6501A means and not test the limits of our imagination as non-tax expert judges in terms of figuring out, well, is it ever going to actually be triggered?
As I understand the question, you mean what is what emphasis to put on the fact of a possibly unlimited time to assess? I think Crim's argument in that regard is fundamentally flawed. He argues essentially that there must be some time limit to assess, but as to the government, the default is actually the opposite. As to the government, a time limitation does not apply by default. Congress must explicitly mandate a time limitation. Here, they've chosen to only limit the time to collect post-assessment, but not to similarly limit the time to collect assessment. So I think that the possibly unlimited time wouldn't add credence to Crim's argument. So I actually wanted to start with the statute of limitations argument. And before diving deeper into those arguments, I think it could be helpful to discuss some relevant background principles of tax law that have come up in the briefing. IRS assessments may be relatively unique in that the IRS doesn't impose a civil penalty when it assesses a civil penalty, just as it doesn't impose a tax when it assesses a tax. Under the tax code, liabilities arise under the statute and are imposed by the statute as a matter of law once the prerequisites have occurred. IRS assessments are just bookkeeping notations, essentially a recording of a pre-existing liability in the IRS's record. So the reason assessments may be important, though, is for triggering administrative collection remedies. The IRS could not collect by levy in this case had it not first assessed. But that brings me to the second point. The government doesn't need to assess in order to collect. Crim is mistaken when he argues that assessment is required for collection. Taxes and penalties may be, in fact, collected without assessment judicially. In practice, that rarely happens because it's far more efficient to collect administratively, but it's important to understand that it can occur. And in fact, if we look at 6501A, and I'm paraphrasing slightly, it says that when there's a tax imposed by the title, it shall be assessed within 3 years after the return is filed, and no proceeding in court without assessment shall be begun after the expiration of the period. So in addition to setting a general 3-year time limit for assessing where a return is filed, it also makes clear that you can proceed in court without assessment.
And I take what you said earlier to mean when it says the return, it's referring to the return of the tax. It cannot be returned. When it refers to the return, it cannot be referring to the return of the client of a tax shelter scheme. I understand you right about that part.
Yeah,
You refer to the Ninth Circuit case saying that, right?
Well, the Ninth Circuit is saying reliance is not an element of the offense, and I think that implies that you wouldn't need to have a tax return that relied on it. A taxpayer could walk up to the ledge, buy the shelter, whatever from you, and then, get wise and never rely on the position, and you still would have made the false representation as.
Well, how broad is this principle that you're asserting? return referred to in 6501A does not refer to the return of the non-promoter of an illegal tax. Does that principle apply across the whole tax code?
Well, I would answer by returning to 6671. 6671 is what says you shall assess and collect in the same manner as taxes, and any reference to tax shall be deemed to refer to this penalty. So it's this penalty that you're weighing against 6501A. For this penalty, when is the return for this penalty filed? There is no return for this penalty. It's not the sort of thing that requires a return. No return will ever be filed. And it may be that no taxpayer ever relied on the furnishing of that advice. It may be that they did rely on the furnishing of that advice, but it may be that they didn't. There really is no case law support for the 6501A argument. Circuits that have seen the issue have rejected it. At least 2 circuits have also held that there's no statute of limitations that applies to assessable penalties such as the 6700 penalty or else the very similar 6701 penalty. Crim also raises an alternative argument about 28 USC 2462. This court should also find that that does not apply to limit the penalty. Again, there is no case law support for that position. And of its own terms, 2462 only applies where Congress has not otherwise provided. But Congress has provided a very comprehensive series of timing limitations in the tax code. It specifically chose to only limit the time to collect after assessment, but not to limit the time to assess, or even to limit the time to collect without assessment. So I don't think it's fair to say that Congress was intending to limit, to use a statute of limitations in Title 28 to limit the collection of penalties in Title 26.
Your time is up, but I'll give you a couple minutes if you want to say anything at all about the constitutional issue.
As to the constitutional issue, we think there's no separation of powers problem with presidential removal. This court's opinion in Koretsky held that in 2015, that the tax court is in the executive branch, and that presents no inter-branch or intra-branch removal problem. We don't think the amendment changed that. Certainly the actual text that was enacted doesn't change the branch in which the tax court is located. And because of that, there is no new question. And a statutory amendment couldn't change all of the underlying constitutional reasoning. This court pretty thoroughly explained that the tax court was not in the legislative branch because it didn't exercise legislative power. And it was not in the judicial branch because it wasn't an Article 3 court that exercised the judicial power under Article 3. That meant the only place the tax court could be was the executive branch, and that's where this court found that it was, and that's where that it remains.
What impact or effect or work do you think that the amended language in 7441 does?
I don't think it has a big substantive effect. I think it clarifies, it makes sure that the tax court is not being treated as an agency. This court already had said it was not an agency, and then sort of left open the question of, well, what does that mean if it's not an agency? For instance, perhaps FOIA doesn't apply. I think adding that to the statute that it's not an agency makes clear that that's true.
What about the independent of the executive branch language?
I think that may just add clarity and comfort that it's independent, but I think it was already independent.
The for-cause provision, removal provision says that judges of the tax court may be removed by the president after notice and opportunity for public hearing for inefficiency, neglect of duty, or malfeasance in office, but for no other cause. Could it be that the work that this amended language is doing is to clarify that inefficiency, neglect of duty, or malfeasance should have very narrow and circumscribed meanings such that the president can't say, I'm removing you for malfeasance because, you took a sick day without a doctor's note, and I'm construing that to be malfeasance, when that might be a pretext for removing someone because the president didn't like their decisions?
I think emphasizing independence could lead to a more narrow construction of the removal power. Sure.
All right, any other questions?
Well, I would have thought the answer to what could we give to Congress's phrase independent of the executive branch is none, because it's just wrong. Resky had said that it's part of can't be independent of the executive branch while being in the executive branch.
I think one way to answer that question, Your Honor, is to point out that Koretsky holds that it's in the executive branch for constitutional purposes, and the independence may be granting statutory independence. I don't know exactly all of the statutory regimes that exist out there, but certainly some of them might, independence might emphasize that those wouldn't apply.
So maybe Congress didn't mean to change whether the tax court is in the executive branch for constitutional purposes.
Right, and it certainly didn't say it's not in the executive branch or say it's in any other branch. I don't think it moved.
I mean, it came really close to saying it's not in the executive branch. It said it's independent of the executive branch. And, in 1776, it would have been hard to say that we, post July 4th, were independent of the United Kingdom and yet still in the United Kingdom, right?
I agree, Your Honor, that it may have come close, but I don't think that's what it said, and I don't think that's what it intended. I think if Your Honor is inclined to think that way, I think you could, though, adopt you could adopt a constitutional interpretation of the statute that does not move it from the executive branch constitutional purpose.
There is such a thing. From my prior life, I studied a lot of the museums and their statutory organizations. And so, for instance, the Holocaust Museum was defined by Congress to be an independent entity of the federal government. It's not within the Smithsonian, it's not within the Park Service or any other agency. It's just its own entity, so to speak. Could that be what the, something akin to that? Could that what Congress is saying here? I mean, I think to Judge Walker's point.
Possibly, Your Honor. I think they're certainly emphasizing independence. Before the 1969 amendment, they were an independent agency in the executive branch. They were then made a court, and that language was dropped. Now they've brought back explicit language to say they're not an agency, but again, to say they're independent of the executive branch. I think that Congress doesn't want anyone calling them to influence their decisions, but as a corollary to being in the executive branch, they must be subject to some sort of presidential removal. They're subject to the same sort of limited presidential removal authority that would be applied to any other multi-member expert body.
All right, any other questions, Judge Rogers?
Oh, thank you.
All right, thank you, counsel. Mr. Rizzo will do 2 minutes for rebuttal.
I would submit, Your Honors, that regarding the statute of limitation, that if this court were to conclude that there is no statute of limitation under the code, the fallback provision in Title 28 applies. The pair of penalties under 6700 were enacted long after the Title 28 catch-all provision, to the extent, and so we all presume that the Congress legislates with knowledge of the existing law. And that's why this court in the 3M decision, in contrast to my opposing counsel's supposition that the default is no statute of limitations against the government, this court rejected that generic statute or canon of construction when it talked about, in citing Chief Justice Marshall's and Justice Story's decisions, that there are competing canons of construction as well. And that's in addition to the rule of lenity and the strict construction doctrine, which stands the proposition that the Internal Revenue Code is interpreted in favor of taxpayers, and against the government. So I don't believe the general proposition that statute of limitations are construed strictly against or in favor of the federal government controls this case. And I would submit that the 3M decision from this court puts that issue to rest. As to the
3M, I think, was an environmental enforcement, some kind of a regulatory enforcement that different than a tax enforcement, right?
that is true, but the language that talks about assessment as being a prerequisite to enforcement specifically referenced Judge Boggs' dissenting opinion in Mulligan. That Sixth Circuit opinion was a 6700 case. So, and then again, in contrast to what my opposing counsel has stated, he is correct that no circuit court has determined that 6700 penalties are subject to statute of limitations. However, the district court in Sage found it was subject to 6501. The district court in Lamb found it was subject to 2462. The district court in Mulligan found it was subject to 2462. And Judge Boggs, in his dissenting opinion in Mulligan, again found it subject to 2462. So there are numerous jurors out there who found that, yes, a statute of limitations, either in the Internal Revenue Code or the catch-all provision, does apply. And finally, Your Honors, I would submit that when Congress got a hold of this court's preceding opinion, make changes to the statutory language because it was unhappy with the status quo. It tried to change the status quo. And perhaps the language could have been better. Perhaps the language could have been clearer. But the Senate report was clear that the tax court is not part of the executive branch. So if the tax court is not part of the executive branch, here it goes, it's an Article 1 court, then I submit then the underpinning for the Koreski decision has been eroded, and presidential removal power from Article 2 and Article 1 legislative court exercising just by the United States violates the separation of powers. So I would ask that, given the arguments in the briefing, contained in the briefing, this court reverse the decision below and remand. Thank you.
Thank you, counsel. We'll take the case under advisement.
Case number 22-5154. Jason Payne, appellant, versus Joseph R. Biden Jr., president. Mr. Hamilton for the appellant, Mr. Winnick for the appellees.
Morning, Mr. Hamilton. We'll hear from you.
Morning, may it please the court. Dean Hamilton, on behalf of Jason Payne, plaintiff. Did Congress provide federal courts jurisdiction over all civil actions arising under the Constitution of the United States in 28 U.S.C. 1331? Does the judiciary have a strong interest in preserving the separation of powers that's been established in our Constitution? And should a federal court determine, without any textual basis whatsoever, that a statutory scheme precludes federal court jurisdiction over a pre-enforcement separation of powers constitutional claim? This court should reverse the decision and remand this case to the district court for adjudication on the merits, because the Civil Service Reform Act does not preclude district court jurisdiction over the type of claim brought by Mr. Payne, which in this case was a pre-enforcement constitutional separation of powers case.
Under your theory, what gives you a cause of action? What is the cause of action?
The cause of action for Mr. Payne, he had 3 complaints. One was a violation of separation of powers. Second was an unconstitutional condition placed on his employment. And third, was a violation of his liberty rights. And so,
But under what statute do those arise? What's the statutory basis for the causes of action?
His claims arise under the Constitution of the United States itself. His claims do not arise under some dispute under the Civil Service Reform Act.
Well, my question is, even if someone said, something unconstitutional was done to me that violates equal protection or the First Amendment or something, then are they filing under 1983? Are they filing under 1981? Are they filing under what? What is he filing under?
Would at the very least be a challenge that would be viable under 1983, but I apologize to the court. I don't have that on this point.
I think 1983 doesn't apply to the federal government.
I'm sorry. So fundamental liberty rights are the same rights that he's alleging arise under Glucksberg, its progeny, about the fundamental liberty right that belongs to every United States citizen from being an interest in privacy and in bodily integrity. So that's not necessarily based on some specific statute. It's based on that right in and of itself. The cause of action for his claim against the President of the United States and against the task force and the other defendants in the case arise under the Constitution itself. It's our position.
Let me shift a little bit. There's something in your brief, I don't have the page in front of me, but you say in order for something to be a proposed adverse action under the Civil Service Reform Act, it requires a specific this, a specific that, a specific this, a specific that, and it's got to be in writing. And in particular, it's got to be addressed to a specific person like Payne. What's the authority for that? Where do I go to find out if you're right about that?
The Civil Service Reform Act itself.
Well, where do I go to? Yeah, basically yes, but I mean, I would even let you go beyond that. You seem, I guess, yes, under the Civil Service Reform Act, it refers to a proposed, quote, proposed adverse action. You say, well, that's not what's going on here because there wasn't specific written notice to Payne specifically regarding a specific suspension or fire. And that actually seems like it might be right. I mean, I'm open to that proposed adverse action requires that kind of specificity, but I can't just take your word for it. I need to know what authority stands for that proposition.
Thank you, Judge. I believe that the Civil Service Reform Act is implementing regulations and the practices of the federal agencies themselves. At the very least, if not directly state as much, indicate as much from their practice. There are no personnel actions are not proposed on a widespread basis that are subject to the CSRA without some kind of individualized determination. It just does not happen. There is a specific individual warning provided or a writing is provided to an individual employee about a specific action that's going to be proposed to be taken, usually issued by the agency in question, to the employee. Then they're able to respond. They're able to consult with counsel. They're able to do all these things. But all of this arises in the context of a specific adverse actions being taken against a specific employee.
I'm going to shift again to the question of whether this is a workplace condition. You argue very strongly in the brief that in light of NFIB v. OSHA, that vaccine mandate cannot be considered a workplace condition. He's been required to wear a mask. He's had restricted travel, a few other things. as a result of defying the vaccine mandate. And I think there would be agreement among the parties that being required to wear a mask at work is a workplace condition. You say, well, you're not challenging the mask requirement at work. But it seems like a pretty kind of easy way to resolve this case is to say, certainly a mask requirement at work is a workplace condition. And in this case, the mask requirement is bound up in the vaccine mandate. There wouldn't, the mask requirement is part and parcel of the vaccine mandate. And so he can challenge the mask requirement at work, which is imposed as part of the vaccine mandate as a workplace condition. He can challenge the mask requirement as a workplace condition. That will allow him to adjudicate not just administratively with the Merits Protection Board, but also eventually with the Federal Circuit, whether the imposition of the mask mandate as part of a vaccine mandate is legal or not, in which case you get into federal court that way. Am I right about all that?
I don't know that it's specifically the case that Congress intended, setting aside whether a mask mandate constitutes a workplace condition.
Well, don't set it. I will let you finish, but said that is a requirement to wear a mask at work a workplace condition?
Under certain circumstances, it could be.
Under this circumstance?
Under this circumstance, I don't think that we're alleging that it is. I mean, hypothetically.
But I'm asking you if it is.
It could be, but the point right now, Mr. Payne, his agency, his employing agency, has subsequently withdrawn any requirements to wear masks among the workforce. There's no longer existent any restrictions on its travel, no restrictions on its entry to the office building. Everything now comes back to the same place that it was when it began, which is the imposition of this vaccine requirement, which the mask mandate was subsidiary to. What I would say about the requirement, the potential eventual availability of a challenge, hypothetically, an employee could challenge a mask mandate as a workplace condition, hypothetically, down the line.
How is he injured right now? Right now?
His injury remains to this requirement to be vaccinated under threat of potential removal from federal service.
Well, I could, say that there's going to be a 10-minute time limit on your argument today, but if I don't enforce it, then you're not injured by it, right?
I don't know. I think that the injury here comes from not only the potential of enforcement in and of itself, but it's the interim effects and the effects that could have come to Mr. Payne, who has.
Why isn't the injury ripe when there is a proposed employment action against your client? So then there's an injury, then there's a cause of action, then there's standing, and then you have a remedy. Why are we talking about this now?
May I respond, Judge? Out of time. Just 1 minute.
Yeah, I don't want to injure you, so you can respond.
Sounds good, Judge. There is a set of circumstances under the fact pattern here where if the agency had proposed an adverse action, or if the agency had taken action against Mr. Payne, where potentially he could, down the line, bring his challenges there. But there's no evidence in the text, the Civil Service Reform Act, or applying Thunder Basin or Eldon, which was limited to an adverse personnel action that was taken, that evinces a preclusion of the general jurisdiction of federal courts under 1331 to entertain these types of systemic challenges to unconstitutional conditions that are placed on federal employees.
So what about, and the district court emphasizes, of course, the provision for going to the special counsel and using that procedure, and then following through as Judge Walker summarized?
You certainly could, although depending on the nature.
You certainly could. Isn't that the end of your argument then? that the statutory scheme eliminates any ability by your client to challenge, much less obtain judicial relief that he seeks.
I don't believe so. I don't believe so.
Why not?
If we were to take that hypothetical and we were applying Thunder Basin.
No, what I'm saying is taking the allegations in your complaint, even assuming the change of circumstances. If we can get over all the hurdles, you can't cite any statutory basis, you haven't any injury right now. There may be one in the future, but right now, and so this is shifting, I realize, but your whole point starts with the premise that the statutory scheme, A, is not comprehensive, and B, even if it is, it doesn't give your client any avenue to relief.
It's not that there is no avenue for relief at some point in time.
I'm
Our
talking
position-
about right now.
Right now, as it stands right now, there has been no proposed individual action taken against Mr. Payne. There has been no adverse action deployed. There has been nothing taken that would put him within the parameters of the CSRA provisions at this point.
Your complaint, however, contradicts that. And I think that's some of the troubling part of this case. Some of your argument is very persuasive, but you can't overlook what your client has alleged. He's talking about humiliation. He's talking about all kinds of other things that has affected his ability to carry out his job, etc. Those are the allegations.
Judge Rogers, I agree that those are allegations that help to illustrate his standing to get into court and to illustrate the harm that has come to him from the imposition of this vaccine requirement. But I disagree with the notion that that puts him within the realm of the CSRA for the reasons outlined in our brief.
No. I know what you said in your brief, and you basically belied this whole process. Even though the district court opinion emphasized it in responding to some of your arguments. That's what I'm not clear about. Judge Walker has raised a fundamental question. Judge Wilkins has raised a fundamental question. It seems to me I'm raising a fundamental question.
Mr. Hamilton, do you have a response?
Judge, I apologize if I misheard Judge Rogers. I just want to, did she say that our complaint, that it lied? Did I understand that correctly, or?
No, I said, here are the allegations in your complaint. We are to take them as true at this point. I made no accusation or implication that what was alleged in the complaint was not true or that your client lied. So erase that from any assumption of any question or response.
All right. Do you have any further response to Judge Rogers or anyone else?
Judge, I would just ask that this court reverse the judgment below because the CSRA does not explicitly preclude Mr. Payne's claim for the reasons we've stated in.
All right. Any other questions, Judge Walker, Judge Rogers?
No, thank you.
All right. We'll give you a couple minutes on rebuttal. We'll hear from Mr. Winnick on behalf of Applee.
Good morning, Your Honor. May it please the court, Daniel Winnick for the government. Plaintiff brought this suit as a preemptive challenge to adverse employment action. The CSRA allows him to seek judicial review of any such action only once it is, quote, taken. That's in section 7513D. If an action is merely proposed, not yet taken, the CSRA is clear that an employee is entitled to administrative process. Notice.
Let me ask, has it been proposed? Is there a proposed adverse action? I know that he can't get into federal court with a mere proposed adverse action, but he can get to the Office of Special Counsel or something like that. So has there been a proposed adverse action?
We haven't taken the view that an action here has been proposed. I also don't think that's relevant even to the question whether he can get to OSC. Whether he can get to OSC, to get there, he has to bring a complaint that there's been a prohibited personnel practice. But our principal argument here is not that this suit is precluded because he has a means of pre-enforcement review. It's that this suit is precluded because the CSRA gives him a means of post-enforcement judicial review, and he's trying to end run that process by seeking judicial review.
I get that, and I have some questions about that in a minute, but I'm just trying to figure out, he says this is a workplace condition, and he says this is a proposed adverse action. And I'm wondering if he's right about both of those, one of those, or neither of those.
We have not taken a position on those issues. We have not suggested that he's wrong about those. I don't think the court needs to say he's wrong about those in order to affirm the dismissal of this suit. The reason this suit is precluded is that he's trying preemptively to challenge.
It sounds like you are saying we shouldn't care, and maybe we shouldn't care if he's right or not, but assume I care. It would be good to have some help from you on whether he's right that this is a proposed adverse action and whether he's right that this is a workplace condition.
Yeah, so I'm not trying to be coy. The reason I'm not taking a firm position as to whether it's a proposed, adverse action is that's for the Office of Special Counsel to resolve if someone brings a complaint. I frankly don't know what view they would take of that, and I don't have authority to sort of get ahead of them on that.
But I guess we should say, I think this is fair to you, but to him as well, that it's possible this is not a workplace condition, and it's possible this is not a proposed adverse action.
I think that's correct.
Okay. Let me then ask about a more general question of on law, Fed courts. True or false? It's possible that a federal employer can plan to violate the constitutional rights of a federal employee, and the federal employee will have no access to an Article III court before enforcement.
So I think, as we pointed out in our briefs, there are various ways in which an employee can sometimes seek reinforcement review, the most basic of which is to go to the Office of Special Counsel. It is a prohibited personnel practice to violate the constitutional rights of an employee. If the OSC finds a violation, it can seek corrective action from the MSPB, and if the MSPB denies it, the employee can then go to the federal circuit. That's one means of reinforcement review. Another, just sort of in I think the hypothetical realm, is mandamus from the federal circuit.
But you said it's possible he's not going to be able to avail himself of that MSPB federal circuit route because it's possible this is not a workplace condition, right?
That's right. A workplace condition is not the only type of personnel action that can be the basis for finding of a prohibited personnel practice. So there's various other kinds of personnel actions, including like taking disciplinary action. So you don't have to think it's a workplace, either in your hypothetical or in this case, you don't have to think it's a workplace.
So is this, I'm talking about the president's vaccine mandate for federal employees. Is that a personnel action?
I think the mere requirement is not a personnel action unless you think it's a change in workplace conditions. So I'm just saying that in your hypothetical, there are various paths by which an employee could seek a pre-enforcement review.
It's not so much a hypothetical as I'm asking for a case, a precedent or some kind of other authority that would stand for this proposition. There will be some instance when a federal employer can plan to violate the constitutional rights of a federal employee, and yet that employee cannot get to an Article 3 court pre-enforcement?
So the best case I have, Your Honor, is AFG versus Trump, which is a recent case from this court applying Thunder Basin and Elgin, where various unions sought to challenge executive orders governing federal labor management relations, including on constitutional grounds. And the court said, the Supreme Court made very clear in Thunder Basin that you do not have a right to pre-enforcement judicial review. Congress can, and it has, permissively channeled the review of those claims into post-enforcement proceedings. The court, noted that that was very clear from the Supreme Court's decision in Thunder Basin, and that's the reason the dismissal of this should be.
And the name rings a bell, but if I go reread that case, it's going to say, at least in that case, possible constitutional violation of a federal employee's rights, no access to Article 3 courts, pre-enforcement of the planned constitutional violation.
Yes, Your Honor. So in that case, unions sought to bring a pre-enforcement challenge to executive orders affecting federal employees, including on constitutional grounds. They argued that they had the right to do that because, and this is from the court's opinion, the CSRA scheme, quote, does not provide for meaningful judicial review because they are unable to obtain pre-implementation review of the executive orders. And this court found that argument, quote, foreclosed by Thunder Basin, as well as this court's prior decision in AFG versus Secretary of the Air Force. And it explained, quote, Thunder Basin instructs that the unions are not necessarily entitled to raise a pre-implementation challenge in the district court, and that Congress may require them to litigate their claims solely through the statutory scheme, at least so long as they can eventually obtain review and relief. And it noted this court said the same in air. And that was the CSRA.
So long as they can eventually obtain relief post-enforcement.
Post-enforcement, yes, as is the case here. If any adverse action is eventually taken, and of course there's no imminent prospect of that because the whole enforcement of this whole requirement has been enjoined by the District Court of Texas, and that's on appeal in the Fifth Circuit. So there's no imminent prospect. But if he is eventually subject to any major adverse employment action, he can appeal that to the MSPB. He can seek review of any adverse MSPB determination in the Federal Circuit. And the Federal Circuit is completely capable of reaching and resolving all of these. And that's a sufficient basis on which to affirm the district.
Let me give you a hypothetical. I think I know the answer to it. Let me just double check. Imagine a federal employer says to its employees, female employees have to work an hour later every day without pay. And if you don't, there will be we have maintained the option of firing. And a female employee wants to challenge that before she has been fired. And you're saying it's possible under our constitutional and statutory scheme that female employee would not be able to adjudicate that question in federal court until she waits for the fire.
So that specific hypothetical, Your Honor, it sounds a lot like a prohibited personnel practice. I mean, one of the prohibited personnel actions is a change in duties, and it's a prohibited practice to do it on a basis that violates constitutional rights. So she can, bring a claim to the OSC, which can, both seek a stay of it and seek corrective action in the MSPB. So I think in that particular hypothetical, she probably can get pre-enforcement review, but to the extent that she can't, this court has made clear that it does not render judicial review meaningless for it to happen post-enforcement. And that's partly because under the CSRA, among the forms of relief the employee can get if he or she ultimately prevails on a claim is back pay, reinstatement, attorney's fees. So it really is a meaningful form of judicial review, even if it comes post-enforcement.
Any other questions? Judge Rogers, Judge Walker?
No, thank you.
Thank you, counsel. Mr. Hamilton, we'll give you 2 minutes for rebuttal.
We'll waive our rebuttal.
All right, thank you. We'll take the case under advisement.